Good morning, members. It's the appointed time. We have a quorum. I call the meeting to order. This is the fifth meeting. It's the Bills Committee on Electronic Health Record Sharing System Amendment Bill 2025. The meeting will last until 10:30. We will not extend the meeting as there is another meeting after hours. Please invite the administration to come in. First, follow-up issues. The Secretariat has issued us with a paper. It's CB-3A39 of 2025-01 is a list of follow-up actions. The administration has given us a reply. It's paper number CB-3A39 of 2025-02. The English version will follow. The attendance list has already been given to members.
先會請我哋政府當局嘅代表簡。
When everyone's ready, we will ask the administration to take us over the paper. That is CB-3A39 of 2025-0, the administration's response. Sam? Thank you. Good morning, everyone. A number of members in the last meeting expressed concerns about the handling of recognized non-Hong Kong health care providers and infrastructures. Members also expressed concerns about the arrangements in relation to suspension and revocation. When that happens, we will disconnect their system with the e-healthcare system. However, under certain circumstances, we allow them to continue to provide new data and information in relation to registered healthcare recipient. Last time, members asked if there was a risk, and the risk was significant. Would there be any impact by allowing these entities to continue to upload information? Our legislative intent is actually very clear. When it comes to a suspension, it means we have a reasonable suspicion. We want to strike a balance between this and the protection of data protection. In the case of revocation, we allow 14 days for the party involved to make a representation. Depending on the risk involved, we will decide whether to disconnect the system or not. In the case of a suspension, we do not give them a blanket allowance to provide information. Our main consideration for this arrangement is that there is a general principle of recognition of these non-Hong Kong providers and infrastructures. We want to give them the recognition under the premise that their system will not impair the integrity or affect the security of our own system. If the reason for the suspension or revocation is something that involves risks to the integrity and security of our system, we will disconnect the system and not allow them to provide information or obtain information from the e-health system. We might not have made it very clear. We will make amendments to clarify the situation I have just outlined. That means when there is a reasonable suspicion, we suspend or revoke the recognition of the parties. And in the latter case, during the period of representation, we may disconnect the systems to ensure the integrity of our system. In relation to wordings, we don't think the suggestion is controversial. We will take on board members' views and make changes in the committee stage. Any questions in relation to the administration's response? If not, we will continue with the clause by clause. We use the Chinese version. On the last occasion, we have completed clause 29. That is to add section 2A in the bill. It's markup version, paper number CB3, 541 of 2025-01. We were at page 54. Now, please refer to page 55. Is clause 29 a suggestion to add part 2B on the blue bill? It's C1166 in the Chinese version. We'll ask the administration to take us through the clause by clause. Members, if you have any questions, you can raise them anytime. We will continue with the clause by clause. Please turn to page 55 of the marked up copy. This is clause 29, that is to add part 2B, provision and obtainment of shareable data by registered healthcare recipients and related persons. Well, patients and carers will get more involved in managing their own records. That's why we add that these two categories of people will be able to provide and obtain information. First is section 26S, interpretation. There are two definitions. First, related person is the meaning under the PDPO. There are people who are unable to handle their own information, so we allow related persons to take care of it. Say, for example, for minors, it will be their parents, or mentally incapacitated person, it will be their guardian or ward. That is in relation to relevant person. The other one is related person. They are people who can access the information. The first type are relevant persons, those ones that I've just mentioned, and the other types are person who's authorized by the recipient. In relation to relevant persons, if it's minor, under the PDPO, we refer to those under the age of 16. Well, the reason is that minor is defined as those under the age of 16, and those above the age of 16, they can choose to manage the information themselves or ask other people to do it. So when it comes to section 39, the reference of minor refers to those under the age of 16. Ms. Doreen Kong. Well, this is something to do with drafting in relation to related person. B, could you just do away with the bracket in the Chinese version Just simply say person who is authorized by, well, just say that a person who is authorized under section 26W bracket 1. There is no need to have those words in bracket in the Chinese version. We will look into it. If there are no other questions, let's turn to page 56. We have 26T and 26U. The first one is about providing shareable information by registered healthcare recipients and related persons. It has to be done in a specified form. 26U is in relation to obtaining data. It has to be done in a form and manner specified by the Commissioner. Next, Division 3, authorization. For those who are under the age over the age of 26 and those that are not mentally incapacitated, because for those under the age of 16 and mentally incapacitated, they have specified persons to handle the process for them. But let me ask a question about actual operation. If someone is no longer a guardian, how does one make sure that the former guardian will not be able to obtain any shareable data? And in relation to 26V, incapable of managing his or her own affairs. So who are these people? There are two questions. First, when we authorize them that they are relevant person, that they are related person, say for example parents, if we are aware that the minor is no longer a minor, then we will send a text to the parents that their children are above the age of 16, so they have to open their own accounts. So we'll be able to identify that. In relation to 26V, mentally incapacitated and those that are incapable. For the former is in relation to those defined by under Mental Health Ordinance Cap 136. Incapable of managing their own affairs has a wider scope. For example, when they are in a coma or when they are in a vegetative state. They are not mentally incapacitated and they are not, that is, they are not under Cap 136, but the fact is that they are unable to manage their own affairs. And that's why the court will appoint a person to handle matters for them. There are legal bases. We'll refer to court documents for confirmation before we authorize them as related persons. Any follow-up questions? No? So let's continue with 26W. This is page 57, authorization of persons. The recipient may authorize another person, but it has to be done in the form and manner specified by the Commissioner. After the authorization is done, then the recipient will receive a written notification from the Commissioner. However, if the recipient is withdrawn from the system, or if the registration is cancelled, or the recipient cancels the registration themselves, then the authorization is no longer in effect. The recipient will have to, in the form and manner specified, apply for a revocation. The Commissioner will then, on a certain date, notify the recipient that the authorization is revoked.
Ms. Rebecca Chan. My apologies, Chairman. I would like to go back a bit. According to the administration, under the bill, a registered healthcare recipient under the age of 16, there are several clauses in relation to minors under the age of 16. Now, in my understanding, in the ordinance, minor is defined as persons under the age of 16, but in other ordinances, the definition is persons under the age of 18. So from the public's perspective, parents acting on behalf of a minor or a mentally incapacitated persons, since we are amending these ordinances in relation to health, can we align the definition for minors either at 18 or 16 years of age? Let's say, for example, for the amendment bill in relation to cigarettes, the definition is for minor is 18 years old. Shouldn't we consider aligning the definitions? Now this one, minor is defined at 16 for cigarettes, 18 for AMD bill. It was 16. Thank you, Ms. Rebecca Chan. Now for the Electronic Health Record Sharing System Ordinance, after consultation, we decided to use the age of 16 as a watershed. So that's for persons allowed to give joining or sharing consent under e-health. This provision is about obtaining or sharing e-health records. Under other policy contexts, there are different definitions. So we think the definition for this ordinance is clear enough. On whether we should align the definitions for minors for all ordinances in relation to making medical decisions, we will study your proposal. Now, in section 26S, you mentioned a person. Relevant person has the meaning given by the privacy ordinance. So is that why you are following the definition for minors under the privacy ordinance? But that's not the case. Under the privacy ordinance, there is not a definition for minors. It refers to the definition given in Cap 1. So under Cap 1, the definition was 18. Now back in 2015, when we passed the e-health record sharing system ordinance, in section 39, it refers to the privacy ordinance, and the definition for that for minor in that ordinance is persons under 16. So that's about the eligibility for making a request to have access to information. Now for parents with children under the age of 18, the parents can make a request to inquire of the health information in the record. Now, under this ordinance, whenever a minor is referred to, then under the privacy ordinance, the definition would be under the age of 16. And minors under the age of 16 can make an inquiry for information. For parents, they can act on behalf of a minor and make the request on their behalf. So since the drafting of this bill, for everything in relation to electronic health record, the line was drawn at the age of 16. So whether it is under the privacy ordinance or management of whatever consents under the bill, the definition for minor is 16 years of age. And we are adopting the same definition. Chairman, follow-up question. As a parent myself, I am quite confused on when the definition for minor is 18 or 16 years of age. Now, of course, the PAS is very familiar with the definitions. But there are already different definitions for minors for gaining access or making inquiries about the information. Now, back in 2015, why did we have separate definitions for minors. If the idea is just to allow minors to exercise their rights as soon as possible, then it's just a matter of education. It's better to align the definitions for minors. Now, despite your explanation, I need to figure out myself under which circumstances the definition of 16 years of age applies. So that is confusing. So what's the difference between defining minors at 16 or 18 years of age back in 2015? That's just my suggestion. Please consider my suggestion. I'm just saying that over the past 2 years, we have several amendment bills in relation to health ordinances. If the age of 18 is what we usually use to define minors, so why are we using 16 years of age here? So I would urge the government to consider Ms. Rebecca Chan's suggestion. Allow me, Chairman. For everything in relation to e-health records, we define minors at 16 years of age. Even for the right to make inquiries about information under the privacy ordinance, we are also using the age of 16. Now, over the past 10 years, since the system was established, it has been running smoothly, but we will consider Ms. Rebecca Chan's suggestion. We understand it may give rise to some confusion. Now, for cigarettes, I suggest 16 because the lower the age, the better. Now, for the cigarettes bill, the definition for minors is 18 years old. I think you should take a comprehensive consideration and align the age at 16. Mr. Ring Kong. Chairman, whether the age of minor is under 16 or 18, that's not the biggest where the controversy lies. The issue is the policy intent and the principle. Now, the definition in the privacy ordinance is 18 years old. Now, when the ordinance was passed, the administration said that they had conducted a consultation, but that doesn't reflect the policy intent or the values that the government holds. Now, there are other places where the definition for minor is set at 21. Is it the government's position that minors under the age of 16 have the right to gain access and have control over their own information? Now, if that's the case, setting aside the findings of the consultation, as a government, according to your position, what principles and values have you applied in setting the age here? I think the government has already explained the principles. Erica. Thank you. Now, after the consultation, we have done some research. It is quite common to use the age 16 as a watershed for allowing a person to have control over their health decisions. In the common law world, there is also the Gaelic competence principle in the common law context. In the context of health, common law jurisdictions commonly uses the age 16 as a watershed. And our decision was supported by the stakeholders and the public, so we adopted the age 16 as a watershed. But we do understand that it may give rise to confusion. So we will review the situation and consider amending it. Thank you. So the principle adopted by the government is that a person at the age of 16 is capable of making a health decision. Thank you. Dr. David Lam, 26W. Authorize a person, does it mean a natural person or a legal person? Both. Now that has an impact on health insurance. Now, a lasting authorization will be given to that person on taking out a health insurance. So obviously, this kind of authorization is excessively powerful. Now, under Section 26W, it seems that you are allowing the healthcare recipients to authorize a person, including an insurance company, to act on their behalf. So would that jeopardize the rights of the patients? Thank you. We were thinking of scenarios where the carers might need to assume control over the information of registered healthcare recipients. So under subsection 2, the authorization must be made in a form and manner specified by the Commissioner. In operation, we would define the context where such authorization is required. For example, authorizing the carers to manage the record, or under social health collaboration, some social welfare organizations need to have access to the record. Now, it's not the case that the purpose of Section 26W is for the healthcare recipients to authorize any person to have access to the information on healthcare, on e-health. Now, form and manner, it seems that the limitation or restriction is too narrow. It may give rise to legal disputes. So would you consider amending the wordings of form and manner? Thank you. Now, the term form and manner appears on several occasions in the bill. Now, for form, it may be filling out a form or a form generated by e-health. Now, for a form, written authorization may have to be submitted to our office. So the Commissioner will specify the acceptable purposes for which these authorizations can be made. From a legal point of view, we would like to be as flexible as possible to accommodate possible scenarios where a carer has to assume control.
Ms. Carmen Khan, thank you. In relation to 16 years of age and 18 years of age, just now Mr. Chen talked about AMD. Well, when it comes to non-resuscitation directions, so it applies to a minor and those that are mentally incapacitated. Well, when it comes to those matters, is the line drawn at 16 or 18? So that I think that is different. from the advanced medical directives. Can you explain to us how come that when it comes to the e-health system, the age of 16 was used? Perhaps in the future you can just come up with provide an information kit. Those above the age of 16 can make the decision to join or withdraw, as well as other informations. It may have an impact on the design of the system. However, whatever decision you make, the most important thing is that it is clear. 26W and 26W3 and 26X3 is in relation to the commissioner notifying the recipient in writing, but not the person receiving the authorization. For example, the mother or the carer, they need to know that the authorization has been cancelled or revoked. I think for the first part of the question, it involves other legislations. I have to maybe wait for the administration to go back to give us to find more information. Yes. In relation to the advanced medical directives or non-resuscitation directives, we will go back to find out more information before we answer you. In relation to the notification in writing under 26W(3) and X(3), well, we write this bill from the perspective of the recipient. That's why we state that the commissioner must notify the recipient. When it comes to the actual operation, of course, the person receiving the authorization will get a notification as well so that they know what to or what not to do. We'll consider whether to make an amendment in this regard. There is a close quotation mark after X(3). Oh, that is in relation to the blue bill 1171 and 1170. But it doesn't appear in the marked up copy, the close quotation mark. Senior Government Counsel, Mr. Chan. In the blue bill, it talks about the entire clause 29. The close quotation and the full stop will not be added to the bill. That is just a matter of presentation, and it's only in relation to the Chinese version. Reverend Kun. I'm not going to argue about where the line is drawn, 16 or 18, but in relation to other pieces of legislation, say for example the mandatory reporting of child abuse, we had a debate. The line was drawn at 18 and here is 16. It's confusing for the public. How come is sometimes 18, sometimes 16? You will have to have consistency because it may give the impression that for some matters is more stringent than others. Under the mandatory child abuse reporting regime, it seems that if you're under the age of 18, you don't have the ability to make the report yourselves. You need to explain more and in a more clearer way. seems that you give more power to those above the age of 16. Stakeholders may find that strange. Well, our country defines a minor as those under the age of 16. I understand that in different contexts, 16 and 18 may be confusing. As I said, we have to conduct a comprehensive review. Whether when it comes to healthcare, we will draw the line at 18. But a decade ago, when we first had the electronic health record sharing system ordinance, the line was drawn at 16. Members of the public are used to it. However, in the future, we will see if we will conduct a comprehensive review. I thank members for their comments. Now we come back to the clause by clause 26X. If there are no questions, we can turn the page to page 58. Clause 30. Amending General Rule. First, Section 27. General Rule. This refers to how the information can be used. We add 28A, 29, 30, 38, 30B, and 30C. We will explain later. Next is Clause 31 to add Section 28A used in connection with advanced medical directives. The e-health system will incorporate advanced medical directives. That's why we state here that the information on the system will be used to ascertain whether there is an advanced medical directive in place and whether the directives are valid and should be applied. When it comes to valid and applicable, we will maintain the same definition as those in Advanced Decision on Life-Sustaining Treatment Ordinance. So 26X. I go back. It says that if there is a revocation, the revocation is recorded and the recipient will be notified. Why not to the authorized person? It's already been answered. Okay then. Let's continue with 28A, page 58. Next is section 29, which is clause 32, used for research and statistics. It says that the data information in the system can be used for carrying out research and statistics. We would like to expand the scope. Currently, it says public health or public safety may narrow the scope. Treatment, the development of treatment, equipment, devices may not be covered using the old definition. You have a new question, Ms. Kong? Yes. Development of medical treatment and devices. Can you clarify? It's rather wide, the scope. Is it? Does it apply to whoever that is doing the development? Section 29 talks about research and statistics. Non-government bodies may make an application, but in other provisions there are clear provisions stating the arrangement. If it is identifiable information, then a committee will have to be set up. An approval will have to be given by the committee. The secretary may impose conditions, say for example compliance with the PDPO, and that the use is of public interest. So these matters are covered by other provisions. Here it applies just not just to the government but other parties as well. Any follow-up? So if it's confined to for public interest, then I'm fine with it. Now let's turn to page 59. Clause 33, adding section 30A, B, and C. First, 30A, use for emergency situations. It says that Hong Kong healthcare provider may, in relation to carrying out emergency rescue operations or provision of relief services, make use of the data and information in the system. The spirit is in line with that in the PDPO. We just want to clarify the intent here. Next, 30B. Use of identifiable data for government-authorized healthcare programs. In previous meetings, we have mentioned that the e-health system will support various care programs. This is a new function. That's why here we make clear that government-authorized healthcare programs may use identifiable data. The information can be used to help the recipient join the scheme for administration of the scheme or evaluation of the program. 30C, use of non-identifiable data for formulation of public policies. The data is important for formulation of policies. That's why we state here that for non-identifiable data, it may be used for formulation of policies. Let's pause here, Ms. Carmen Khan. I have a question for sections 30A and B. These are new. These two are new, right? Yes. Here it says identifiable data. That means the data can be identified. Is able to identify the person. In reply to Ms. Kong's question, it says that the applicant may not be a government body. Clause 32 in 0060. Are we at page 60? No. But here it says an application to the secretary. So identifiable and non-identifiable. I'm sure that when it comes to the meaning of non-identifiable, people know that you can't use the information to identify the certain person. So for identifiable data, there is this wording for public safety. You have expanded the scope by adding more words. So for identifiable data, it can be used on the development of medicine, medical treatments, or medical devices. How come you need identifiable data for this purpose? And how do you be the gatekeeper?
Thank you, Ms. Carmen Khan. On the difference between identifiable and non-identifiable data, as Ms. Carmen Khan mentioned, for identifiable data, these include ID card number with which I can identify the identity of the person. For non-identifiable data, I can't trace the data back to the owner. That's defined in Clause 2 of the bill. And there are other sections defining the use of e-health record data. Section 29, research and statistics purpose. 30, B, government authorized healthcare programs, and 30C, public policies. Now 30B, healthcare programs. For healthcare programs, it is necessary to trace the information to the owner so as to manage the progress of the program. For 30C, on public policies. Now for formulation of public policies, we can only use non-identifiable data. Now for 29 research and statistics, the scope is wider. Now later on, we will come upon the progress for approving the use of data. For research and statistics purposes, sometimes we need to use identifiable and sometimes non-identifiable data. Now, there is a mechanism for the Commissioner to consider a range of factors before approval is given. Since identifiable data is concerned, there will be a more rigorous approval process. A panel will be set up to consider the relevant considerations, and then a recommendation will be made for the Commissioner's approval. So there are different mechanisms for different scenarios. Chairman, some questions about the panel. What is the composition of the panel? Will there be experts and professionals? The panel concerning the approved use of identifiable healthcare data. Now, it is not included in the markup copy because it is in the original ordinance. Section 32, 33, and 34 in the original ordinance. It has already provided for the mechanism for use of identifiable data. Section 30, a panel has to be established to consider factors like whether the use of the data for statistical purposes is ethical and whether only identifiable data can achieve the purpose. And also whether there is a way to get to obtain the consent from the data owner before the use of data, and whether it justifies public concern or public interest. Ms. Doreen Kong, Chairman, concerning sections 30, B, and C, use of identifiable data for government-authorized healthcare programs and formulation of public policies, and also for the research and development of medical treatments or medical devices. These are new provisions. Now, when eHealth 2.0 is launched, I assume that the government would make an effort to explain all these to the public. Will you explain the use of that data to the public? Yes, on joining, we will explain to the public that by joining the eHealth, it is also giving a consent to share the data for these uses. And also, we will make sure that the potential applicants for using identifiable data understand the mechanism clearly. So we will make sure that both the stakeholders and the healthcare recipients understand that this mechanism exists. I have this worry because on joining these health programs, especially for elderly people, the forms are filled out by others without them having read the form. So we have to make the warnings conspicuous to the public. Reverend Peter Kuhn. Chairman, I would like to confirm Section 30B For healthcare programs and the use of identifiable data, the healthcare recipients can opt out to share their identifiable data on e-health. And also, I think you have to give us some real-life examples. Section 30B is very sensitive. I can foresee that many people would opt out of joining the e-health simply because of the existence of Section 30B. I know the government is only obtaining the data for benevolent purpose, but I think many people will be deterred from joining because of this. Thank you, Reverend Peter Kuhn. 30B, brackets A, for enrollment of the healthcare recipients in any healthcare program authorized by the government in which the healthcare recipient has consented to participate. So first of all, the healthcare recipient has to give consent to join the healthcare program. Only then will the information be obtained from the e-health platform. And only then will the healthcare recipient be making available their identifiable healthcare data for these programs. If there are no further questions, let's move on to page 60. Page 60 of the markup copy, Clause 34 amending Section 32, application to Secretary for use for research or statistics purpose. So that's the procedures for making the application. So like Section 29, we are expanding the scope to development of medicine, medical treatments, or medical devices to align the provisions. Ms. Doreen Kong. Section 32 and 35 are very similar. One is about identifiable data. The other one is about non-identifiable data, both for research or statistics purpose. But upon comparison, there is only one major difference. In one, application is made to the Commissioner. In another, the application is made to the Secretary. So the PAS said that the application must premise upon public interest, but I can't find the word public interest in neither of the provisions. You are setting out the specifics about the application, but you are not laying out the principle to the public. Thank you, Ms. Doreen Kong. Section 30, application for using identifiable data. For that, approval by the panel and the Secretary is required. For non-identifiable data, an approval by the Commissioner is required. Now for Section 33, the panel will consider whether it is the only way to achieve the stated purpose. Concerning the word public interest, please refer to Section 33, subsection 2E. It provides that the panel has to consider what public interest will be served, and also what public interest will be served by using the private data of the recipient. Now, the mechanism will only be implemented after the passage of the bill. Ms. Carmen Khan. I was going to ask the exact question explained by the PAS. Now, I saw that the two provisions are not implemented yet. There is not a commencement date for both provisions. So what's the government's plan down the road? Have you foreseen a scenario where a notice will be published to commence these provisions. Now, Section 33, you said you have mentioned the factors to be considered. So maybe you can submit a written supplementation to us to explain the difference. We want to know the factors considered by the research board and also the secretary or the commissioner in giving approval. Now, this research board, what is the composition of it? To facilitate our scrutiny, please attach the relevant provisions for our benefit. Now, will a research board only be established when the secretary has to consider an application, and not the case for an application made to the commissioner? Timetable of commencement and the establishment of the board. Thank you. Now, healthcare data is valuable to research and development of medicines, but since privacy is concerned, we need to establish a mechanism to gain access to these data. We will establish the mechanism within the legal framework before applying these data to research and statistics purposes. Now, Ms. Carmen Khan is right. Identifiable data is sensitive data, so under the law, a research board will be established to approve the use of these data. For non-identifiable data, under the ordinance, the use is already allowed. Now, this scrutiny exercise only focuses on the provisions with amendments, so we will supplement the relevant provisions without amendments for members' benefit. I think this is very important because we are establishing our primary evaluation platform. So the framework is very important. So I hope that the provisions will take commencement as soon as possible. Mr. Rin Kong. Now, when the research board is to make a decision, will the decision be made public? Also, will members of the research board have to declare the conflicts of interest? Now, in the past, for non-identifiable data, the commissioner can give an approval. Now you have extended the scope beyond public safety and public health. So for non-identifiable data, a research board is still not involved. Section 33 doesn't say that the research board has to consider the factor of public interest. Thank you, Ms. Kong. On whether the decision of the research board would be made public or whether declaration of interest has to be made, this bill only provides a framework without the specifics, but I think these are very sensible approaches. Concerning the procedures for using non-identifiable data, please refer to Section 35. The applicant has to state the public safety or the purposes of the research, and the research board will have to consider whether the use of the data is ethical. So the research board will not just give approval to any applicant.
36(1) decision of the commissioner. The scope is rather wide. It doesn't talk about public interest or other factors. It just says A and B. Well, now the scope is a lot wider. It can be used for research. Perhaps you need to amend Section 36 to provide a better safeguard. You said it's good for the public, but I hope that you will make sure that the public know. Section 35 mentions public interest, but if it is not clear enough, we will go back to look into it. When it comes to the actual operation, we'll bear in mind what the member has said. Mr. Chen Pui Leung, when it comes to users of identifiable or non-identifiable data, how long can they retain the information? Is there a requirement that they need to dispose of the data and information? In addition to the data user, a third party may be engaged to conduct the research. Are there restrictions on the use of data or information by third parties? The provisions are to set down a framework, not the details. The Secretary may impose conditions, say, for example, that the information and data should not be forwarded to a third party, and the information should be disposed of when it's no longer in use. So conditions may be imposed. So there will be conditions imposed when an approval is granted, and it's not stated in the law. That's right. Sam? When it comes to the use of identifiable data, there are procedures. In the public and private healthcare sector, the use of identifiable data is happening because the information and data is used for development of medicine. If there is a collaborative project to select patients of a specific illness so that medicine or treatment under research can be tested, identifiable data is used. An approval has to be obtained from the research board. And specific information about the use of the data, how the data is used, how long it will be kept, restrictions on the use of data by other parties, all these have been set out, and this has already been happening. The procedure and the principle of the use of identifiable or non-identifiable data is the same compared to the one proposed in the bill. The requirements on the scientific and ethical requirements are actually the same. Ms. Khan, in the original provisions, are the commissioner or the Secretary empowered to formulate code of practice to handle these matters. These provisions are not in operations yet, but now you want to expand the scope to the development of medicine, medical treatment, or medical devices. Regarding declaration of interest and management of interest, how will they be handled? Through subsidiary legislation, the code, or have they been provided for in other provisions? Yes, under 52, Section 52, the Commissioner may promulgate code of practice in relation to implementation. I hope that the future code of practice will cover these matters. Members of the research board will have to handle the conflict of interest very properly. You may need to cover matters relating to cross-boundary use. Ms. Doreen Kong. Just now, Mr. Chen Pui Leung put a very good question. Under sections 32 and 35, if an approval is given, the Secretary or the Commissioner may impose conditions. What will happen if there is a non-compliance of these conditions? 46 is not amended. So if there is a non-compliance of conditions, there is just a level 6 fine. But that is in relation to identifiable data. There is nothing about non-identifiable data. Under 35, the Commissioner may impose conditions, but it doesn't say in the legislation about consequences of non-compliance. Am I mistaken? Or is it because there are other considerations? In relation to illegal forwarding of data and information to third parties, I think there is a penalty. Regarding non-identifiable data under the PDPO, it's allowed in the use of research or statistics. However, in the report, the data should not be made identifiable. Well, since we're dealing with non-identifiable data in this regard, and there are no specific provisions, if someone uses personal data illegally, there are already provisions handling these matters. We understand how it's dealt with under PDPO, but whether it's strong enough is a different matter. Well, Section 46 only covers the situation when the Secretary is involved, but it doesn't say anything about the Commissioner. If you think there is no need to cater for such situation, then just let us know. We will go back to consider it. Let's continue with the clause by clause. Page 61 of the marked up copy. Clause 35, amending Section 35, application to Commissioner for use for research and statistics purpose. Well, that's the same treatment like the previous one. Now we turn to page 62. Clause 36, amending Section 37, prescribed healthcare providers' duties to restrict access to health data. This is technical in nature. It states the duties of prescribed healthcare providers. They are local ones. Under 37 2A, we add Hong Kong, and there is a similar one in another provision. That is 37(3). Now, clause 37 to add 37A, authorization of persons. Just now we mentioned that the Commissioner may, in relation to sections 30B and C, that is identifiable data on healthcare programs and formulation of policies in using non-identifiable data. So that's the authorization by the Commissioner in those cases. 30B is important because it refers to identifiable data. It says may authorize a person. Who? The definition, the scope is rather wide. 30B refers to the Hong Kong SAR government. Sometimes non-government bodies may manage the program, say for example hospital authority. So the Commissioner is authorized, it has the power to authorize the hospital authority to manage these programs. Ms. Khan. This is my concern. In relation to the authorization, it talks about imposing condition. Would you consider adding those words? Should it also say that the Commissioner may impose conditions under the authorization to cater to address the concerns we have expressed? We may consider it. Yes, it's rather generic. It just says that it's authorization by the Commissioner. Whether we add it, we need to add in a form and manner specified. We will go back to consider it. Page 63. Clause 38, amending Section 39, privacy commissioners' performance of functions or exercise of powers. This is a technical amendment to replace e-health system with e-health system. Next is Section 40. It's also a technical amendment to replace system with e-health system. Now page 65. Clause 40 to add sections 41A and B. Two sections are added to stop people from using the name and logo of the e-health system to mislead others. First, 41A. Offense relating to purporting to be or holding out as e-health system. If someone without the consent of Commissioner establishes or maintains an information infrastructure that purports or holds itself out to be e-health system or associated with it, then it's an offense. It's a fine at level 3. 41B is the use of the names. If a person establishes or maintains an infrastructure and mislead others into believing or being reckless as to whether the person would be misled into believing, that is an offense. The titles are electronic health system, e-health system, e-health in Chinese, 電子健康系統, 醫健通系統, 醫健通系統, the Chinese names of the above, or any other titles that closely resembles those set out just before. If someone commits an offense, the person is liable to a fine of level 3.
Mr. Ring Kong, I think there is a great risk here. 1441A, if you hold yourself up to be associated to e-health, the fine is just $10,000. Thank you. The legal advisor has also inquired about the severity of the punishments. We have referred to offenses of a similar nature under other ordinances. For example, the Chinese Medicine Hospital Ordinance, the Baptist University of Hong Kong Ordinance, and the HKAPA Ordinance. So the level of fine for these ordinances is set at $10,000. Now, scammers are running rampant in Hong Kong. We need to be careful about scams. Patients' data is important. I think the offense should carry at least an imprisonment terms. Now, for purporting to be part of the e-health system, the punishment is only $10,000. That's too lenient. We do understand that there is a lot of sensitive information on e-health. For unlawful use of the data, the consequences may be serious, so we will reconsider the level of the fine levels. Now, 41A, according to the legal advisor, inquired whether it is a strict liability offense. Now, the prosecution has to prove the mens rea of the defendants unless it is an exceptional case or if there are alternative pathways. Now, for this, the mens rea need not be disclosed. Mr. Kenneth Leung. Sections 41A and B about offences relating to the establishment of or maintenance of an information infrastructure. Now, what if such an infrastructure does not exist and that the operators only relies on the e-health? Do the defendants need to have, say, a website established to commit this offense? Now, whether an actual information infrastructure is needed or whether a piece of infrastructure which looks like an information infrastructure will be sufficient for the commission of this offense, that depends on the case. Ms. Rebecca Chen, the PS mentioned that mens rea is needed. Now, Section 41A about the title, e-health system, electronic health system, and e-health, I follow all these, but there is subsection 2D. In Chinese, 電子健康系統. That's a generic term. For example, if a hospital claims that it has an electronic health system that is 電子健康系統 to digitalize the healthcare record, that's quite a common term. E-health or e-health system, these are quite specific. But by including this generic title in the provision, there are genuine electronic health systems run by various healthcare organizations, and they may run afoul of the law. Now, the official name for electronic health system in Chinese is 電子健康系統. In drafting the bill, we have considered the concern of the member. So in 41 brackets B, there must be a mens rea to deliberately mislead another person to believe that the system is part of e-health, to qualify for the offense. So intent is important here. A simply coincidental case will not be an offense. Now, of course, there must be an intent to hold yourself out to be e-health. You need to have a similar design of the interface and the website. But in my opinion, the name 電子健康系統 is quite common among healthcare organizations. I have reservations whether this name is exclusively used by the government. So a patient may ask whether a healthcare organization have a digitalized platform. So I hope these would not be seen as offenses because intent is important here. Ms. Judy Chen. I agree that this name is quite common. So there are lots of potentially problematic situations. So besides titles, what about logos? And would you consider registering the name of electronic health system as a trademark to enhance the exclusive use of the trademark? As I said, the intent is important here. One must be deliberately purporting or holding itself out to be e-health to commit the offense. Now, for intent, Section 41A, one way of purporting itself to be part of the e-health system is by using a similar logo. So in terms of the title and the logo of e-health, we have registered them under the law to enhance the security. Ms. Carmen Kan. Thank you, Chairman. Considering Section 41A, I'm aware that the legal advisor has asked the question whether the offense is a strict liability offense, because it seems that only the actus reus is important here. Establishes or maintains an information infrastructure. As long as you did that, it would be an offense. However, according to the PS just now, the prosecution needs to prove the mens rea of the defendant, but that's not what the wording said. So maybe an amendment is needed here. On the other hand, 41B is much clearer. There must be an intent to mislead any person into believing or being reckless as to whether the person would be misled into believing. Now, since in Part B, the intent to mislead or being reckless as to whether a person would be misled has been clearly stated, I'm satisfied with that. But that doesn't exist in Section 41A, so maybe we need to supplement Section 41A. And I think we need to reconsider the punishments for these offenses. It is illogical to impose the same level 3 fine on establishing or maintaining an information infrastructure and misleading another person into believing that the infrastructure is part of the e-health. Yes, we do agree that we haven't. The components of mens rea is not clearly stated in the bill. That's why we made the inquiry. So please study the level of fine as well. Mr. Rincon, just very briefly, Section 41B, the very similar titles. Have you conducted a search to see in Hong Kong and in the Bay Area, are there healthcare organizations owning similar titles? I would hope that you have conducted some research to ensure that this bill will not affect other organizations. Like Ms. Rebecca Chan said, 電子健康系統 is a very common name. What about the English version, electronic health system? There may be other organizations which held this title long before you. It would be unfair to them to criminalize the use of this title. Now, not even a title similar to the title is allowed. Now, in Hainan, there is a digital health system. So would this name be contravening your law? P.S. Thank you. Concerning the title, when we applied for a patent for the name electronic health system or e-health, we have conducted research. That is a unique name not used by anyone else. The name e-health, however, has been used by others. So that's why we have included the elements of criminal intent in 41A. It is not a strict liability offense. You won't be committing offense only when the system looks like e-health. There must be criminal intent. What about the similar titles like digital health system? I refer you to Section 41A or B. Now, 41A, something holding out as e-health system. If there are additional actions to hold itself out to be e-health to others, then it would be an offense. A mere coincidence of the name with no intent to mislead others does not constitute an offense. If the users understand that this digital health system belongs to a hospital in the Bay Area, then that's not an offense. Let's move on. Page 67. Clause 41, amending Section 43, offenses relating to impairments to system. A technical amendment to the title and subsection 1, replacing system with e-health system. Page 68, Clause 42, amending Section 47, offenses relating to direct marketing. By way of background, information on e-health cannot be used for direct marketing. That's already stipulated under the existing ordinance. But there are exemptions. Please turn to page 69. For situations like provision of public health services, the direct marketing restriction is exempted. Now, 8B, healthcare services provided or administered by the Department of Health or the Hospital Authority. Now, besides the D of H and the HA, there are other organizations as well. So we have added the Primary Healthcare Commission or healthcare facility managed or controlled by the government, the Hospital Authority or HA subsidiary. And 8BA, healthcare services provided under any healthcare program authorized by the government. These will be exempted. If there are no further questions, let's move on to page 70.
咁呢個係關於第40
This is clause 43 to add 47A, B, C in relation to enforcement notice. There was a previous discussion on 26P and R, that is, prescribed healthcare providers have to provide information and data into the system. Now we elaborate on the enforcement notice. First, 47A, offenses. Failure to comply with enforcement notice is an offense. Before legal proceedings, an enforcement notice will be issued. And if there is failure to comply after the notice has been issued, then the party will be subject to level fine penalty, and continuing offense will be subject to a daily fine of $1,000. Well, there are some defenses. First, that the person has already raised an issue and that reasonable steps has been taken. Next is burden of proof. The provider needs only to establish a defense. The prosecution will have to produce the evidential proof. Well, there is a time limit for prosecution. It's 2 years after the date when the offense was committed. 47B. If the enforcement notice is not complied with, before any legal proceedings, the Commissioner will have to first issue a penalty notice. By paying the penalty, then the party will be able to discharge the liabilities. And if information has been supplied in compliance with the enforcement notice, then a prosecution may not be initiated. And then we talk about in Section 4 that within 21 days, the person may raise a dispute in relation to the liability. And 5 says that, Schedule 4 has no effect in relation to the person giving the notice as mentioned. 47C, failure to comply with the enforcement notice. If the penalty is not paid, or if the penalty is paid but the information is not supplied, or if the information is not supplied in the first place, that is, a failure to comply with the enforcement notice, then the Commissioner may initiate legal proceedings. Once it's done, the penalty notice is deemed to have been withdrawn. Ms. Kong. Well, it was going very fast. I would like to go back to page 69. B4. Managed or controlled by. In your mind, what services will be covered by 4 by 4? B4. What services do you have in mind? Currently, there are a number of organizations that are managed or controlled by the government. Say, for example, the District Health Center, as well as government-run Chinese medicine clinics. I have a suggestion on drafting. It says here 8B, healthcare services provided or administered by a healthcare facility managed or controlled by. It's rather a mouthful. Can you see? Can you add that is? And then 47C. 47 relate to enforcement notice and penalty notice. I had to draw a chart to help me understand. 47C2. Can you explain? Why is there a wait of 21 days after the issuance of the penalty notice? What's your rationale? Please consider the addition of that is. Now, 47C. In Schedule 4, there is a mention that there is a period of 21 days. So if you raise an issue within 21 days, then the mechanism in Schedule 4 will be triggered. And enforcement notice and penalty notice, they are two different things. But can one dispute a enforcement notice and the penalty notice can be disputed as well? Yes. Back in 26P, Section 26P, the decision by the commissioner may be disputed. It should be raised with the Administrative Appeals Board. I've read through 47A to C. It's a cumbersome procedure. You have to keep raising a dispute every 21 days. Well, even if someone makes frivolous disputes, it's only a small amount. It's just 1,005 plus 1,005 plus maybe another $500 for costs. There is no deterrence at all. I don't have any issues with genuine disputes. But someone may make use of the system. Well, there is a low fine, so people may abuse the system. There are different tiers. First is the enforcement notice. Before that, there is the penalty notice. If it's complied with and if the information is uploaded, then the liability is discharged. Failure to comply will result in recovery notice, a recovery order. There is another $1,500. It's a summary procedure. Which is an easier way to discharge one's liability. However, if there is repeated non-compliance, legal proceedings will be initiated. The penalty will be level 5, that is 50,000. It's not a jump to 50,000. We give opportunities to the parties to fulfill their legal responsibilities or liability. Ms. Judy Chen. I also would like to ask direct marketing. In Hong Kong, there are strict restrictions when it comes to the use of a doctor's or a clinic's name. However, there is a new trend mainland healthcare organizations have advertisements here in Hong Kong, but they are not subject to our law. You want to do more with the e-health system in cross-boundary collaboration. How do you deal with crimes or deception cases? Section 47, direct marketing. Data or information in the e-health system should not be used for direct marketing. Personal information in the healthcare providers system will be regulated by the PDPO. There are requirements. Consent should be obtained. Without it, the information should not be used for direct marketing. Local healthcare providers will be subject to local laws. Providers outside will not be covered. Under the bill, if they are healthcare organizations outside Hong Kong, conditions will be imposed when recognition is made. The conditions may include the use of data and information. The same spirit is adopted. That means the information and data should not be used for direct marketing. Next, Ms. Lam So Wai. 47B. 4. 21 days. A dispute. 21 days. Calendar days or working days? Do we refer to Schedule 4, 9, bracket 6? Do we take holidays into account? We will adopt the same principle under existing legislation. If it's not clear enough, then we may make amendments to specify whether it's only working days. Now is calendar days. Thank you. Dr. David Lam. The penalty. Well, daily fine of $1,000 if the information is not provided after the penalty is paid. I think you need to consider the actual situation. What information is required? We're talking about information of hundreds of patients. The healthcare provider may not be able to do it within the specified period of time. It may take time. I think you will have to take that into consideration. Sometimes it may have to do with the system itself. We are not computer whiz kids. Clinics may not have a system that have perfect interface with the system. I can tell you that we encounter difficulties every day. And if the onus is on me and I don't have what it takes to handle the information, then it doesn't work. It has happened to me. We were told that the matter is referred to the R&D section, and it took 10 days. With the daily fine, it means over $10,000. We have to obtain a consent from the patient not to upload the information. The patient may ask us not to upload the information. Then we ask the patient to notify the system. Maybe the patient simply forgets that he asks us not to upload the information, but we are the ones that are penalized. How do you deal with it? Can I act in accordance with an instruction on the system instead of a verbal instruction from the patient? I think you have to take into account the actual situation, the difficulties we face. What's the most important thing? When you go to see a doctor, what's most important? Is how the system works or your ailment? There are many things that we have to comply with. If we have to tick all the boxes, there's no time for consultation. The defense. If the patient specifically told me that the information should not be uploaded, that should be a defense. You have to ensure that the patient has not given me the instruction. So, actual situations relating to failure to upload information.
Thank you. 3 questions. In section 47A, the legal procedures have been initiated, and on establishing the offense, the defendant is liable to a level 5 fine and a 1,000 fine for every day during the continuing offense. So that's the maximum fine. A level 5 fine and a continuing penalty for the continuous offense. Now, if all signs point out that the defendants could have rectified the situation immediately, then the court would decide to impose the $1,000 per day continuous penalty. This is just about the maximum penalty. Now, in operation, we need to work out the implementation details of the mechanism with the trade. In terms of the grounds for defense, it has to be issued in the form and manner specified by the Commissioner. So in the future, the Commissioner will publish the acceptable form of application to be made by the patient not to upload the information on the eHealth. That would serve as a safeguard for both patients and doctors. Now, in the future, we will consult the trade on the format and manner of that application. Now, before the prosecution, the Commissioner will have to conduct an investigation and interact with the healthcare providers and the patients to ensure whether the requirement has not been complied with. The Commissioner would consider whether the healthcare providers have already uploaded the information in the format or spectrum specified by the Commissioner. Now, this enforcement notice would not be issued where a consent has not been made. So I think this shouldn't be the doctor's responsibility to state this defense. It should be the government's responsibility. Why isn't that written so in the bill? And also the format. We don't know what the format is like. We don't have a say whether to upload or not to upload the record pertaining to a certain encounter with the patients, and we don't know when to upload them as well. Now we would receive a notice on a request to upload the data, and then 10 days later, the notice would appear again. But I would have no idea whether information has been uploaded in the interim of the 10 days. And still I would be fined. If there is a system for the patients to make a clear request not to upload their information, that would be best. You are just notifying me that the patient has made this request not to upload the information pertaining to a certain encounter. That's it for me. No further action should be required on my part. There's so much I have to do. We have to write the medical record, we have to prescribe medicine, and we have to conduct the medical procedures. And you are asking me to interact with this system on whether information should be uploaded for this encounter. Sorry, I can't do that. We should automate the majority of the procedures. The government and the patients should share the burden as well. Now, concerning latency in uploading information and so on, I think after the passage of the bill, you need to keep in touch with the sector. Thank you. Now, before the issuance of the enforcement notice, maybe we should interact with the doctors. And the commissioner should be required to consider the findings from the interaction with the doctors. I think that's the direction we can further consider so as to make the provisions clearer and offer better safeguard to healthcare providers. And we will consult the Bills Committee when we have considered the suggestion. Now, concerning the workflow mentioned by Dr. David Lam, we have considered different options. For example, providing an option on the system for the doctor to take after consulting the patients, or offering this option on the app for the patients to submit this application. Now we will consult the trade to ensure that there are no excessive obligations are imposed on the trade. We don't want to add to the workload of the health carers, but there is inevitably an adapting period after the passage of the bill. So communication is key here. It would be very frustrating for the medical sector if it's too cumbersome. Ms. Carmen Can. Now in Part 5, we are focusing on the offences, Section 41A and B, new offences in relation to establishing or maintaining an information infrastructure purporting to be e-health. We have discussed whether the punishment is sufficient for that offence. And Section 42, offences in relation to gaining access to and impairing the system. Now, there are more hefty punishments carrying imprisonment terms. Now, Section 44, there are enforcement notice and penalty notice for enforcing the previous requirements, and there are the 21 prosecution period. Can we have a flow chart on all these, since you are also considering whether the punishment levels are commensurate with the offences, and also you are considering Dr. David Lam's suggestion on offering sufficient time for the accused to discharge the duties. So can you provide us with a flowchart? Thank you. Please provide us with such a timetable and also the flowchart. It's now 10:25. I suggest we pause here. We don't want to start a new part yet. So we pause at page 72 of the markup copy. The next meeting will be held after a date is decided. For the follow-up matters, the administration will provide us with written supplementations. Meeting adjourned. Thank you.